And it's also another reason that you're speaking out.
I can tell you this one thing. I may have been born at night, but I was not born last night. And one thing about it, you cannot fool the informed. I've been on the inside. I know the process. And we will not sit quietly and allow this to be swept under the rug. I will call your hand. I will call your hand. You are not going to play these people for a fool. You are not going to play these people for a fool. We know the process. We know what you should be doing. And by God, I plan to make sure you do it. Or we're going to call you out each and every time. There is a process. What I do know is, had the roles been reversed, by now, there would likely have been already arrests made.
A body pulled from warm Gulf water. A red mark no one can yet explain. And now, for the first time, a man who once had the power to sign arrest warrants for a living says he believes he'd sign one for this case too. That's not a headline. That's not speculation from an anonymous account online. That's a former Mississippi municipal judge, speaking under his own name, walking through the evidence point by point and reaching a conclusion out loud. Tonight we're going to walk through that same evidence with him, carefully and without pretending an opinion is the same thing as a verdict. It's worth understanding up front just how unusual it is for someone with this specific background to speak this directly about an open case. Most legal commentary on cases like this one comes from attorneys who have never actually signed the kind of warrant being discussed. Here, the person making that assessment spent years doing exactly that, in the same state where this investigation is unfolding. That doesn't make his opinion correct. It does make it worth understanding in full, rather than reducing it to a single quote pulled out of context. Before anything else, no one has been arrested, no one has been charged. What follows includes the personal legal assessment of a named attorney and former judge, offered publicly and on the record. It is his opinion, clearly identified as such, not a finding of guilt, and nothing here should be read otherwise. If you want the kind of coverage that separates a professional's opinion from a proven fact, instead of blurring the two together for a better thumbnail, that's the whole reason this channel exists. Subscribe now, because this case has more still coming: the neck structures, the toxicology, and whatever a grand jury eventually decides. Nolan Wells was 18 years old when he disappeared from Horn Island on the 4th of July. His body was recovered from the water 2 days later. In the weeks since, his family has fought publicly for a level of scrutiny they say should never have needed a fight in the first place, flying his body to Washington, D.C. for an independent autopsy, hiring civil rights attorney Ben Crump, and watching as the case drew the attention of the knockup, the FBI, and now a former sitting judge willing to say, plainly, where he believes the evidence points. Tonight's update centers on that judge's assessment, the specific findings from the second autopsy that shaped it, and the growing list of unanswered questions surrounding the officials who handled this case first. Before we go further, it's worth restating the same boundary that has to govern every part of this discussion. Legal opinion is not legal fact. A former judge's read of publicly available evidence is a genuinely informed perspective, shaped by years actually spent on the bench, but it is still one person's assessment, offered outside any actual courtroom, without cross-examination, without a defense response, and without the full body of evidence that only a real investigation can eventually produce. Treating that opinion with seriousness and treating it as a verdict are two very different things, and tonight is built entirely around keeping that difference intact. Attorney Carlos Moore is not a bystander commenting from the outside. He served as a municipal judge in 2 Mississippi jurisdictions, Clarksdale and Grenada, for roughly 6.5 years, with the authority to sign search warrants, arrest warrants, and preside over hearings for offenses up to and including murder. He has also worked directly with the forensic pathologist at the center of Nolan's independent autopsy, Dr. Roger Mitchell, on past cases, including a prior matter in Mississippi involving a young man who died under circumstances the family considered suspicious. That professional history is why his public assessment of this case carries more legal weight than most commentary it gets compared to, and why it's worth examining carefully rather than either dismissing it or treating it as settled fact. It's worth understanding, too, what Dr. Mitchell's own credentials bring to this case. He has served as Chief Medical Examiner for Washington, D.C., led the National Medical Association, and overseen pathology work connected to Howard University's hospital system. Families in cases like this one commission independent examiners specifically because they don't trust the state's process to be the only voice in the room. And Mitchell's resume is part of why his conclusions, however limited by the evidence available to him, carry weight of their own alongside the state's official findings. The independent autopsy, conducted by Dr. Mitchell shortly after Nolan's body was recovered, produced a preliminary set of findings that Ben Crump announced publicly. Those findings are what Moore says he was responding to. Within roughly 2 weeks of Nolan's death, his case had already drawn national attention, an FBI statement, and a commitment from the county to eventually refer the matter to a grand jury. It's against that fast-moving backdrop that Moore chose to speak, after seeing the autopsy results, not before. It's worth being precise about the sequence Moore has described, since the order in which each development arrived matters for understanding why his statement carries the weight it does. He has said publicly that in earlier commentary on this case, before the independent autopsy results were available, he was unwilling to offer an opinion on whether the evidence supported an arrest for murder specifically, though he indicated at that time there may have been enough for lesser charges, without specifying what those might be. It was only after reviewing the preliminary autopsy findings that he moved to the more serious assessment he's offering now. That progression, declining to speculate, then updating his position once new evidence arrived, is itself a meaningful part of how seriously his current statement should be weighed. According to Moore, Dr. Mitchell's independent exam could not determine a definitive cause of death and could not rule out foul play. That's a meaningfully different starting point than the one offered by Jackson County Sheriff's Office, which said within roughly a day of Nolan being found that no foul play was suspected, a conclusion reached, per Moore's account, without the benefit of any forensic examination at all. Moore has been sharply critical of that early timeline, arguing that a sheriff's office reaching a confident conclusion before a single autopsy has been performed is exactly the kind of sequence that erodes public trust in how a case like this gets handled from day one. It's worth pausing on why that particular sequencing matters so much to how this case has unfolded publicly. An early, confident statement ruling out foul play sets a kind of default expectation, one that every subsequent finding then has to work against, rather than simply build on. When Dr. Mitchell's independent exam came back unable to rule out foul play, it didn't just add new information. It directly contradicted a conclusion the public had already been given as settled weeks earlier by an office with no medical findings of its own to support it at the time. That contradiction is a meaningful part of why this case continues to draw such intense scrutiny of the officials involved, separate entirely from whatever ultimately turns out to have happened to Nolan himself. Much of what's driving suspicion in this case isn't physical evidence at all, it's behavior. Moore has pointed to a list of things he considers suspicious, based on what he's read and what the family has described. That no one has publicly come forward to say they witnessed Nolan enter the water, despite hundreds of people reportedly on the island that day. That some of the friends who were with him did not, according to accounts he's seen, join the search effort the following day, and that some did not attend his funeral. It's worth being precise about what this actually is. These are behavioral observations, offered by a specific attorney as reasons for suspicion, not confirmed facts, and not on their own evidence of a crime. Innocent explanations for any one of these things are possible, and none of them have been tested in a courtroom. At the same time, it's worth noting that not every friend in Nolan's circle has drawn this same suspicion. Moore has said he personally attended Nolan's funeral and observed at least 2 of the young men who had faced public criticism online there in person, visibly grieving alongside the family. That detail matters for keeping this segment honest. The suspicion being described here applies to specific unnamed individuals whose conduct has been questioned, not to every friend who was on the island that day, and it should not be read as a blanket accusation against Nolan's entire friend group. The independent autopsy documented a specific, unexplained finding, an area of red discoloration in the soft tissue at the back of Nolan's head. Dr. Mitchell was unable to determine, to a reasonable degree of medical certainty, whether that discoloration was the result of an impact or simply a natural effect of the body's extended time in warm water. Critically, he found no wounds and no fractures, nothing indicating a laceration or a broken bone in that area. The body had also decomposed significantly by the time of the second exam, which limited what could be assessed on the surface of the skin for bruising or other marks. It's worth being exact about the size and meaning of that finding, since it's the single most discussed detail to come out of the independent exam, a discoloration substantial enough to be documented separately in an autopsy report is not a trivial detail, and it's understandable why a family already skeptical of the state's process would view it as significant. At the same time, discoloration of this kind can, under the right conditions, result from entirely natural post-mortem processes, blood settling in tissue depending on how a body was positioned after death, particularly after an extended period submerged in warm coastal water. Dr. Mitchell's own conclusion reflects that real uncertainty rather than resolving it. He did not call it evidence of an impact. He also did not rule one out. That open question, honestly stated by the examiner himself, is exactly why this case remains unresolved rather than settled in either direction. The phone remains one of the most contested details in this case. According to accounts the family has shared, Nolan's phone was not recovered from his body, but was later found in the possession of one of the friends who returned from the island without him. And, according to that same account, content including messages and photos had gone missing from it. It's important to be exact here. This is a description from the family, not yet a confirmed forensic finding. A coordinated, professional examination of the device is what would be needed to establish whether anything was deliberately removed and by whom, rather than lost through ordinary means. There's a related detail worth including for completeness. According to Moore, the friend or friends who ended up with Nolan's phone did not proactively report it missing to law enforcement and did not voluntarily return it or Nolan's car keys to his parents. His father reportedly had to specifically request the keys after some delay. None of that, on its own, proves anything was hidden or altered. People under stress, especially young people suddenly at the center of a missing person situation, don't always respond the way investigators or the public might expect, and fear of unrelated trouble can produce behavior that looks suspicious without reflecting any involvement in a death. What can be said honestly is that the family, and more, view this sequence, a missing phone, a delayed handoff of keys, and reportedly deleted content, as significant enough to warrant a full forensic review, one that has been agreed to but has not yet produced a public result. It's worth being clear about what a forensic download would actually need to demonstrate before any of this moves from suspicion to something with real evidentiary weight. It isn't enough to show that certain content is currently absent from the device. Investigators, or the family's own retained digital forensics expert, would need to establish that specific messages or photos existed on the phone at some point after Nolan's disappearance and were then removed deliberately by an identifiable person at an identifiable time, rather than lost through routine app behavior, such as automatic content expiration built into some messaging platforms. That is a meaningfully higher bar than simply noting what isn't there now, and it is exactly the process both sides have reportedly agreed to undertake. The Jackson County Sheriff's Office's early public position was that no foul play was suspected. That statement was made before the independent autopsy, and before, by Moore's account, any state autopsy findings had been fully shared publicly either. It has not been formally withdrawn, but it now sits alongside a forensic opinion that explicitly cannot rule out foul play. Two official positions that, at minimum, are in tension with each other. It's worth stating plainly what this tension does and doesn't tell us. It does not necessarily mean the sheriff's office acted improperly. Early statements in missing person and recovered body cases are sometimes offered based on the immediate circumstances at the scene, before any forensic work has begun, and are later refined as more information comes in. That is a normal part of how investigations evolve. What makes this instance harder to explain away is the specific word choice and the confidence with which it was delivered. Not, "We have no reason to suspect foul play at this early stage," but a more definitive statement that foul play was not suspected, issued within roughly a day of the discovery of a body. That level of certainty, offered that quickly, is what critics like Moore argue set the tone for how skeptically the public has viewed every official statement in this case since. Dr. Mitchell's exam was also limited by what he did not have access to. According to Moore, several pieces of evidence that could have helped answer the central questions in this case, Nolan's neck structures, his lungs, his stomach contents, and the state's original toxicology results, were retained by Mississippi state investigators and were not made available for the independent examination. Moore has publicly questioned why a portion of that material or an invitation to examine it directly wasn't offered to Dr. Mitchell, calling the absence of the neck structures in particular a significant gap, since it left open the question of whether an injury to the neck may have played any role in Nolan's death. It is worth being fair to the other possibility here too. Retaining tissue for a state's own ongoing examination is not unusual procedure on its own. What made this specific retention notable to Moore was less the retention itself and more the lack of any coordination that would have let the independent examiner review it as well. Each of those missing pieces closes off a different avenue of the investigation, and it's worth walking through what each one specifically would have told investigators. Access to the neck structures could have helped determine whether compression or another form of neck injury contributed to Nolan's death, a question that currently remains entirely open. Access to lung tissue is typically how examiners assess whether water was present in a way consistent with drowning, which means that, as things stand, drowning itself has not been forensically confirmed as the cause of death, only assumed as the most likely explanation given the circumstances. Stomach contents can sometimes help establish a general time frame for when a person last ate relative to death, offering another data point toward reconstructing the final hours. And toxicology, as in virtually every case involving a body recovered from water after several days, is often the deciding factor in ruling out alternative explanations altogether. Without any of these four things, Dr. Mitchell's inconclusive finding wasn't a failure of his own examination. It was close to the only honest conclusion available to him given what he had to work with. Two separate accounts of Nolan's final hours still don't line up. A young woman who was reportedly the last person to speak with him has described him expressing an intention to rejoin the group's boat. The friends who returned without him have described the opposite, that Nolan chose, on his own, to stay behind. Neither account has been confirmed as accurate over the other, and it remains possible that something changed between that conversation and whatever happened afterward, a gap that has not been publicly explained by anyone involved. A second, related contradiction sits with the Coast Guard's own account of when this became an active search. One of the friends on the boat has said he called to ask about Nolan around 11 that night. The Coast Guard's own record of that call has needed correction since it was first described publicly, and by most accounts, whatever was said during that call was not enough, on its own, to trigger an immediate formal search. That leaves a real gap between when concern about Nolan's whereabouts first reached an official channel and when an organized search effort actually began, a gap that, like several others in this case, has never been fully explained in public by any of the agencies involved. This is exactly the kind of moment where most coverage collapses a real contradiction into a verdict, and it's exactly where we're going to keep slowing down instead. If that's the kind of true crime coverage you actually want, make sure you're subscribed, because the next confirmed detail in this case could shift everything we just laid out. This is where Moore's public statement becomes most significant. Speaking after reviewing the preliminary autopsy findings, Moore said that if he were still sitting on the municipal bench in Mississippi, and if an investigator presented him with an affidavit documenting the details made public so far, including the unexplained discoloration, the disputed phone, and the behavior he considers suspicious, he believes there would be enough circumstantial evidence to meet the legal threshold to sign an arrest warrant for one or more unnamed persons in connection with Nolan's death. He was careful to frame this as his own legal judgment based on publicly available information, not as a formal charge, which does not exist, and not as a determination of anyone's guilt. It's worth explaining precisely what that threshold actually means, since it's frequently misunderstood in public discussion of cases like this one. Probable cause, the standard Moore is describing, is a considerably lower bar than the standard required to actually convict someone at trial. It asks only whether the available facts would lead a reasonable person to believe a crime was committed and that a specific person may have been involved, not whether that belief has been proven beyond a reasonable doubt. A judge signing an arrest warrant on that basis is authorizing an arrest, not delivering a verdict. Moore's statement, in other words, describes an opinion about the threshold for suspicion, not a conclusion about guilt, and the distance between those two things is exactly where this case currently sits. Moore has also joined public calls, including from the NOCP for the U.S. Department of Justice's Civil Rights Division, to become formally involved, arguing that the racial dynamics surrounding this case, Nolan being a young black man whose friend group was reportedly predominantly white, deserve direct examination as part of any thorough investigation. He has separately called for Mississippi's Attorney General to send investigators to examine whether any local officials mishandled evidence or delayed the investigation improperly, and for the U.S. Attorney for the Southern District of Mississippi to open a concurrent federal review, noting that Horn Island itself is federal property, which gives federal authorities standing jurisdiction alongside the county sheriff's office. It's worth explaining why an independent autopsy so often ends in undetermined, rather than a clean answer, because it isn't unique to this case. A forensic pathologist working without full access to organs, tissue, and toxicology results is, by definition, working with a partial picture. Cause of death in cases involving prolonged time in water is frequently established only after ruling out alternative explanations, which is precisely why missing lung tissue, missing stomach contents, and missing toxicology data matter so much here. None of that proves wrongdoing on the state's part. It does mean that the independent examination Nolan's family commissioned was operating with real limitations that were not of the examiner's own making, and that a more complete picture may still depend on cooperation that, as of this recording, has not materialized. There's a further layer of nuance worth adding here, one that applies to how any tampering or obstruction question would eventually get evaluated if it were ever formally investigated. Retaining organs and tissue for a state's own internal examination is standard, unremarkable procedure in the overwhelming majority of autopsies, entirely independent of whether a family later requests a second opinion. What separates ordinary retention from a real transparency concern is whether a state's medical examiner's office makes a reasonable effort to coordinate with an independent examiner once one has been retained, sharing findings, offering access to retained material, or at minimum explaining clearly why that access hasn't been possible. According to Moore, that coordination has not happened here in any way the public has been made aware of, and that absence, more than the retention itself, is the specific thing driving his concern. Public suspicion in this case has expanded well beyond the friends who were with Nolan that day. Advocates, including Moore, have pointed to the state's chief medical examiner's broader track record in prior cases involving young black Mississippians found dead under unusual circumstances, arguing that a pattern of rulings against foul play, case after case, deserves independent scrutiny in its own right. That is a serious claim about an official's professional record, and it is presented here as exactly that, a claim made publicly by a named attorney, not an established finding. The NOCP's involvement and the calls from multiple public figures for federal oversight reflect a broader distrust that is built around how local officials have handled this case from its earliest hours. That distrust has also extended to how different agencies are seen to interact with one another. Some commentators following this case have argued that local, county, and state agencies tend to protect one another when accusations of mishandling arise. One office investigating another and reporting back that nothing improper occurred, with no independent party ever reviewing that conclusion. Whether that pattern applies in this specific case has not been established, and it remains, at this stage, a concern being raised rather than a documented fact. It is precisely the kind of concern, though, that formal DOJ or federal involvement would be positioned to examine directly, which is part of why that call has become such a central demand from the family's advocates. The volume of attention this case has generated, across news outlets, legal commentators, and independent media hosts, has itself become part of the story. That level of scrutiny has almost certainly contributed to the pace at which institutions have responded so far. An FBI statement, a grand jury commitment, and a public statement from a former judge, all within weeks rather than months. Whether that same pace would have existed without this volume of public attention is impossible to answer definitively, but it's a fair question, and one that both supporters and critics of how this case has been handled have raised in different ways. As of this recording, no arrests have been made, and no charges have been filed in connection with Nolan Wells' death. The independent autopsy remains preliminary and inconclusive on cause of death. Neck structures, lung tissue, stomach contents, and full toxicology results from the state have not yet been made available to the family's examiner. A coordinated forensic review of Nolan's phone has not yet produced a public finding. The case is expected to move toward a grand jury once the underlying investigation concludes, though officials have said that referral alone does not confirm any particular outcome. Several specific developments would meaningfully move this case forward from where it currently stands, and it's worth naming them clearly so viewers know exactly what to watch for next. First, any decision by Mississippi's State Medical Examiner's Office to share the retained neck structures, lung tissue, or toxicology results with Dr. Mitchell's team, or to explain in detail why that hasn't happened. Second, the completion and public disclosure of the coordinated forensic phone examination both sides have agreed to. Third, any response from the Department of Justice or the U.S. Attorney's Office to the calls for federal civil rights review. And fourth, whatever a grand jury ultimately decides once the underlying investigation is considered complete. Each of those, individually, could shift this case significantly in either direction, toward formal charges or toward a documented explanation that resolves the questions currently surrounding it. What can honestly be said tonight is this. A well-credentialed former judge has said, in his own professional opinion, that the circumstantial evidence made public so far would meet his own threshold to sign an arrest warrant. That is a serious statement, and it deserves to be taken seriously as exactly what it is. One experienced legal opinion offered publicly based on an incomplete picture that even its author acknowledges is incomplete. It is not a charge, it is not a conviction, and it does not resolve the central, unanswered question at the heart of this case. What actually happened to Nolan Wells in his final hours on that island? It's worth closing by naming the two very different things that are true at once here, because holding both is the only honest way to leave this update. The first is that nothing described tonight has been proven in a courtroom, no one has been formally accused of a crime, and every individual connected to this case is entitled to the presumption of innocence, unless and until that changes. The second is that a case built entirely on an accidental drowning does not typically produce this volume of missing evidence, unexplained physical findings, disputed digital records, and public statements from credentialed legal professionals questioning the process itself. Both of those things can be true simultaneously, and reconciling them is exactly the work still ahead for investigators, and eventually, for a grand jury. What remains constant, through every new detail, is what his family has asked for from the beginning. Not a predetermined outcome, but the same thorough, transparent process any family would expect if this had happened to their own son. Nolan Wells was 18 years old. He is not here to tell us what happened. Until the evidence that's still missing is finally accounted for, no one else can honestly tell us either. There is one more thing worth saying plainly before we close. Cases like this one tend to generate two opposite failure modes in public conversation, and both of them do a disservice to the people actually involved. One is to treat every new development as proof of a predetermined conclusion, guilty or innocent, before the process has actually run its course. The other is to treat the sheer complexity of an ongoing investigation as a reason to disengage entirely, assuming nothing will ever be resolved either way. The more honest position sits between those two, staying engaged with each confirmed detail as it arrives, resisting the urge to fill in the gaps with certainty the evidence doesn't yet support, and holding institutions accountable for closing those gaps rather than leaving a grieving family to do it themselves. We're going to keep following this case exactly as carefully as it deserves. The missing tissue, the phone examination, the toxicology, and whatever a grand jury ultimately decides. If you want those updates the moment they're confirmed, and not 3 weeks later buried under recycled headlines, subscribe and turn on notifications. We'll see you for the next one.